So, Ms. Anthony, you'll be first. Are you going to reserve 5 minutes?
Yes, Your Honor.
Okay, we're ready whenever you are.
Good morning. May it please the court. Stephanie Anthony on behalf of the appellant, Taylor & Fulton Packing, LLC. This is an appeal from a summary judgment that was entered in favor of the appellees, Gorgeous Hamlin Knowles and Hawk PA and Timothy Knowles individually. It's Taylor & Fulton's contention that the trial court erred in entering summary judgment. Specifically, the summary judgment appears to be predicated on the appellee's contentions that the legal malpractice arose out of litigation and the defendants were not the proximate cause of the adverse outcome of the underlying action, which resulted in the damage to the client.
So, Ms. Anthony, if I can ask you a question, I'd like to jump right in there because I was pondering this proximate cause issue. Because as you know, your opponent has argued that the successor attorney in the bankruptcy did not take whatever actions they could have taken and availed themselves of the remedies available to them as to the Mayaca property and the bankruptcy proceedings. And that's why they had this loss. And specifically, the bankruptcy related to the corporate entities. The Mayaca property was owned by Mr. Granger in his individual capacity and therefore is not part of the bankrupt estate. And the position is that they should have gone to the bankruptcy court, make clear that there was no stay that related to Mr. Granger or this property, and then either record the mortgage specifically only as to that property, which they could have done, or to otherwise, proceed to try to take action against that property. And I guess even more inexplicable in the individual action that was brought against Mr. Granger, that action itself in state court never really addressed any efforts to, use the Mayaca property to satisfy the losses that Taylor & Fulton suffered. So I know it's a big question, but it's all geared at the same thing: the Mayaca property and the failure of the successor lawyer to go after it to make his client whole.
Okay, Your Honor, I'm going to try to answer that as best I can. So,
well, it's proximate cause is what it is, so, and that's the key here.
Yes, Your Honor. So what happened, and there was a lot that led up to the bankruptcy filing, which was expedited by Mr. Knowles' conduct. But so when the bankruptcy was filed, Taylor & Fulton had to prioritize its efforts and the relief sought in the bankruptcy case. There were two things that they could have done initially, but their focus was to get the member interests in Taylor & Fulton that were held in escrow by Mr. Knowles and his firm. The member interests were their priority because without the member interest, Taylor & Fulton was not able to negotiate with its primary secured lender, Rabobank. And they were in default on that. They were paying default interest. And Mr. Knowles knew this because he was also representing Taylor & Fulton in connection with a potential refi of that Rabo debt with a bank called Alistar. So Taylor & Fulton stepped forward and was trying to get the member interest first and foremost so they could deal with their secured lender. Otherwise, they might have ended up in bankruptcy as well. Now, with respect to the mortgage that was being held by Mr. Knowles, who under that same theory could have still recorded it as to Granger individually, since that would not have been stopped by the automatic stay.
Well, how could he have recorded it against Granger individually without reforming it? Because it did not apply to Granger at all. Your clients got lawyers. You got Mr. Stroud, who drew up this document. Mr. Turner testified, yes, I knew we didn't secure Granger's personal real estate assets. I knew that. They also knew Granger was in debt up to his ears. They also knew he had $16 million in superior mortgage liens on all of his properties. But yet they agreed to that. But they also made Mr. Knowles the escrow agent, and they also agreed to the fact that he had 3 business days to record it. So they were the ones that decided whether it got recorded and when it got recorded. And they also knew, Mr. Turner testified he knew that Mr. Knowles was also representing Mr. Granger and Taylor Fulton. So help me out here.
So with respect to the recordation of the mortgage, that was just one of 2 things that Mr. Knowles was supposed to do.
But do you agree with me? You cannot record a mortgage against Myakka Farms without getting Mr. Granger to reform the note by putting his personal signature on it, correct?
I think that Mr. Knowles could have made a notation at the top of the mortgage.
Did your clients ask him to do that? No, they fired him.
Actually, he was not fired.
He was terminated on April 30th by Mr. Stroud.
He was not.
By email.
He was not. He was terminated with respect to, actually, I'm not sure he was terminated. He continued, and if you look at his fee application, you can see that he has continued to negotiate with Taylor and Fulton, or on Taylor and Fulton's behalf. I mean, it seems like it was erroneously billed to the Granger Estates, but you can see in his narratives how he's continuing to work on the benefit of Taylor and Fulton for the refinance with Alistar.
Because the remaining members allowed him to continue to represent the company for the refinancing instead of firing him. But they're still blaming the same guy for malpractice, yet they're still using him to do work into September of 2015. I'm just trying to place this into context, because this legal malpractice action appears as if your clients were really surprised that this all happened.
I think
when they were all longtime friends. Every one of them was a longtime friend that trusted each other. And Mr. Turner said he really didn't need a conflict waiver to allow Mr. Knowles to represent Mr. Granger.
I think everyone thought that Mr. Knowles would do what he was supposed to do under the escrow and the assignment. And the assignment provided that the member interest would have been turned over 2 business days following the default, which would have happened, it should have happened before the bankruptcy. But Mr. Knowles took it upon himself, and you'll see in his deposition testimony, he made a value decision. That decision was against Taylor and Fulton and in favor of his other client, Granger. He chose, instead of to move things along to comply with the assignment and the escrow, he chose to focus all weekend long to facilitate the expedited bankruptcy filing of the Granger entities. He didn't get notice until after 5 p.m. on Monday, the second business day following the default notice, where he should have already turned over those member interests. Granted, the mortgages gave him 3 business days, but the assignment gave him 2 business days, and he did not turn over those member interests because he was focused on preferring his other client, the Granger individual and entities. That's what he did. He sat on his hands waiting for his bankruptcy counsel that he hired for Mr. Granger and those entities to file. There was no excuse of the automatic stay for him to not turn over those member interests. He had 2 business days.
Did he violate the escrow agreement?
He violated.
Yes or no?
To the extent he was holding in escrow the member interest.
Did he
yes.
violate the provisions of the escrow agreement?
I think the escrow agreement primarily related to the mortgage, but there was a second document that provided that he held in escrow the member interest, and he did violate that agreement.
Well, Mr. Stroud testified at his deposition that by April 29, 2015, Knowles only represented the company, Taylor Fulton, for refinancing the loan, and that Stroud represented the company and that Knowles represented Granger personally. That's April 29. That's before he was asked to record the mortgages. So he doesn't even represent your client then.
Well, he does represent them in connection with the refinance. And I
Okay,
don't.
but this isn't about the refinance.
But you can't take an adverse action against a current client on any matter if they're a current client, and they were.
Yeah, but Mr. Turner's own attorney testified under oath that that was agreeable to them.
Agreeable to them that he.
To Mr. Turner, Mr. Stroud testified that Mr. Knowles represents Granger personally. Mr. Stroud represents Taylor Fulton as of April 29, 2015.
That does not excuse a lawyer's obligations to, first of all, I don't think that was a waivable conflict. I don't think whatever anybody said makes that a waivable conflict under the professional rules that we are governed by. But regardless.
But your clients waived a conflict by executing the escrow agreement.
It's not waivable. It wasn't waivable. It wasn't explained to them. And they certainly didn't know that it was Mr. Knowles' intention all along to never comply. He insisted on being that escrow. When they originally drafted the documents, it was Blaylock Walters.
So your client was forced to agree to that?
I think they trusted him.
Oh, now they trust him, so it wasn't forced.
Yeah.
Your argument's
I didn't
inconsistent.
No, I didn't say Mr. Knowles requested to be the escrow. And because he had been Taylor and Fulton's general counsel for, I believe, since its inception, nobody thought that Mr. Knowles wouldn't comply with his responsibilities under the assignment and the escrow, and in violation of the rules of professional responsibility.
See, one of the things I'm having trouble with, and Judge Sleets touched on this, Ms. Anthony, is, and I'll ask the question this way: what is the worst thing in your mind that Mr. Knowles did to basically vitiate the duty that he had? What's the number one thing? The smoking gun here.
Okay, and you'll see in the emails that are of record between Mr. Knowles and Stichter Rydell, where Mr. Knowles was asking, what if I comply with what I'm supposed to do pursuant to the escrow? Can it be undone?
A preferential transfer, yeah.
Right.
What's the date of that email?
Well, I mean, I saw that, and I don't understand why that's a bad thing to have asked. He just didn't know. He wanted to know. But at the end of the day, he did record these mortgages within a 3-day window, right?
No, he never did. He never did what he was supposed to do because he was waiting for the letter.
I mean, somebody here thinks he did. So you're saying the mortgages were never recorded?
Correct, Your Honor. What happened was the notice of default was sent from Robert Stroud on April 30th. That's a record at 1038 through 1042. Then upon receipt of the notice of default, Mr. Knowles emails Scott Stichter and Amy Harris of Stichter Rydell on Friday, May 1, 2015. That's a record at 1778. And he states, a client in the tomato and citrus business is about to have his entire financial world collapse. Can you or someone in your office be available for consultation immediately?
Well, Miss Anthony, here's the problem. There's an email from Robert Stroud to Steve Tornio saying,
that's right.
our firm
Yeah.
is engaged to represent Taylor Fulton Packing LLC, period. Mr. Knowles no longer represented Taylor Fulton. He was just the escrow agent, was he not, as of April 30th?
No, he was. He was still
How
counsel.
so? How so when Mr. Stroud, the attorney for Mr. Turner, indicates to someone else that he is the attorney as opposed to Knowles?
a
He
corporation.
even copied Knowles on this email.
Right. He was
So
the
if he's
attorney.
not the attorney of Taylor Fulton, then he has the fiduciary duty to Mr. Granger for his best interest. So to reach out to the Stichter firm can't be a conflict if he no longer represents your client, correct?
He still represented the client, Your Honor. You can have more than one attorney and more than one firm representing an LLC.
You're at
And,
15 minutes, Smith Anthony, just so you know.
okay, Your Honor.
And I do recall that the reason the mortgages weren't recorded is because the bankruptcy stay stopped them. I've
Yes, Your
forgotten
Honor.
about that. Yeah,
And I know I'm at 15 minutes, but I'd like to finish answering
Go
your
ahead.
question, which I think was what's the worst thing that happened? Well, if Mr. Knowles had turned over the membership interest within the 2 days that he was required to do, then during the bankruptcy, Taylor and Fulton could have focused on getting the mortgage reformed. Instead, they had to focus on getting the member interest so they could work on the refinance with Rabo. Mr. Knowles knew how important that was. It would have crushed their whole business and they would have ended up in bankruptcy themselves. And during the negotiation to get those member interests, to which Mr. Knowles was a part of, using his personal knowledge of his client, Taylor and Fulton, he insisted on a release in favor of his other client, Granger. Because of the need for the member interest and the fact that there was a senior lien on the mortgage at the time, that release was given, but it was a part of a negotiation, mitigation efforts, and that does not excuse the wrongdoing by Knowles.
okay.
And I'm out of time. So.
Okay, you'll have 4 minutes when you return though, okay? All right, thank you. Ms. Heim?
Good morning. May it please the court. My name is Lori Heim, and I represent the Appellees in this case, the Porges Hamlin Knowles and Hawk PA law firm, and one of its principals, attorney Timothy Knowles. I'd like to address.
Ms. Heim, can I just say something before you get going?
Certainly.
Mr. Knowles was in and around and all over these clients and these transactions. Would you agree this is reckless behavior for a lawyer to engage in?
Respectfully, Chief Judge.
Would you do it?
I cannot comment on what I would do at the time with the relationships that Mr. Knowles had.
This is pretty outrageous, actually. The question really is it actionably outrageous? But it's outrageous for a lawyer to be in and around on both sides, all over the place. I mean, if I've never seen a lawyer ask for trouble, this lawyer was asking for trouble. The question is, did he get it?
To address your specific question, Your Honor, with whether Mr. Knowles's conduct was reckless, in response to that, I would say it was not, Your Honor. The motion for summary judgment that was granted by the trial court was correct. I'd like to address the specific counts of the complaint because the terms of the documents that were executed by the parties bear specifically on those counts. Count 1, of course, is a breach of contract action. That action arises from both the escrow agreement, which addresses the mortgage, and the collateral assignment, which addresses the interest. As a result of Mr. Turner's back channeling after mediation with Rabo, a default on the note was ensured. The default notice was provided on April 30th, 2015. The deadline under the collateral assignment to transfer the interest was May 4th. There is no time period set forth in that collateral assignment for when those interests had to be transferred to the appellant. Mr. Knowles testified that he was well aware that Mr. Stroud's law firm had a mail slot for after-hours delivery. The bankruptcy petitions were filed by the Granger entities on May 4th. That stopped everything as it relates to the escrow agreement and the collateral assignment. Of course, the escrow agreement mandated recordation of the mortgage by May 5th, but that again could not be done, as has already been mentioned today, because of the petition. So under the plain language of those contracts, there was no breach. thus warranting summary judgment as to count 1. Counts 2, 4, and 5 are addressed to various alleged breaches of duty by the appellees: breach of fiduciary duty, breach of the duty of loyalty, and breach of the duty of care. Those counts, as well as count 1, are barred by paragraph 4 of the escrow agreement, because that paragraph specifically provides that the escrow agent shall not be liable for any action taken in connection with the escrow agreement, except for gross negligence, reckless behavior, or intentional conduct. Counts 1, 2, 4, and 5 do not allege any of those types of conduct or causes of action. Therefore, summary judgment was appropriate as to those 4 counts. I also would like to direct the court's attention to paragraph 11 of the escrow agreement. In that document, appellant at that point was managed by Mr. Turner through Utopia Fresh. Appellant acknowledged in paragraph 11 of the escrow agreement that the appellees had represented Mr. Granger and his entities with regard to the mortgage, and specifically consented to continued representation in any future matters related to the mortgage. That escrow agreement makes it clear that future representation by the appellees of Granger and his entities was specifically contemplated by the parties to the escrow agreement and was consented to by all parties. Appellant's counsel made reference to Mr. Knowles' decision to act as the escrow agent. There is nothing legally improper about that. In fact, paragraph D of the escrow agreement specifically provides that the parties requested Mr. Knowles to act as the escrow agent. The language of those documents, when coupled with the language in the confirmed plans that were also in the record, which provide exculpation provisions, results in counts 1, 2, 4, and 5 being properly the subject of summary judgment in favor of the appellees. Turning to count 3 for fraud in the inducement, it's the appellee's position that, again, paragraph 11 of the escrow agreement specifically bars that fraud claim because, again, everybody recognized the role that the appellees had taken up to the point of the escrow agreement and consented to continued representation of Granger and his entities in the future. And it's also important to point out that post-petition, the appellant did not object to the appellees being hired as special counsel to the debtors in the bankruptcy cases. There was specific reference by Chief Judge Morris to the state court case that was filed post-petition. That case alleged a myriad of claims against Mr. Granger personally. That case was dismissed. That case also in no way attempted to pursue Myakka Farm. I would submit to this court that appellant's counsel's response to the questions by this court that the member interests were the priority does not excuse the complete lack of any effort to pursue Myakka Farm. A plain reading of the mortgage demonstrates that Myakka Farm was not part of any bankruptcy estate. And the trial court was correct in using the phrase the inexplicable decision by bankruptcy counsel not to pursue Myakka Farm, and as well for Myakka Farm not to be pursued in that post-petition state court action against Mr. Granger. The fact that obtaining the member interest was a priority in no way operated to exclude the available remedy of Myakka Farm, but that remedy was not pursued. Turning then to the issue of proximate cause, it's the appellee's position that the evidence in the record demonstrates that the proximate cause of the Appellant's loss was first and foremost the diversion of the funds by Mr. Granger. The appellees had no participation in that conduct, had no control over appellant's finances or appellant's financial records. Next, the bankruptcy filings themselves were a proximate cause of appellant's loss. It is in the record, Mr. Turner specifically testified he was well aware of the potential for a bankruptcy filing post-workout, and Mr. Granger specifically testified that had he been pursued personally, he would have also filed for bankruptcy.
I don't recall that being his exact testimony. I remember him saying that he never really contemplated it. And then later he thought it through and said, well, if they would have chased me, I would have thought about it. That's what I understood. You made it a little more emphatic than I read it.
I certainly not my intention to
That's okay.
mischaracterize the record, Your Honor.
It's not an important point, but I just remembered it differently.
Well, I have a question. I have a question about context because it appears to me that these were all longtime friends, correct?
Yes, Your Honor.
And they had a relationship that was long-term. Mr. Turner realizes that money's going out and it's going to Mr. Granger. So he goes to Mr. Knowles at a tree lot and says, go talk to Granger, figure this thing out. And everything is kind of loose. They're not really rule followers. They all trust each other. But then Mr. Stroud gets involved and represents Mr. Turner. Mr. Stroud takes it upon himself to draw up all of these documents. Mr. Knowles didn't draw up these settlement documents. Is that true?
That is correct, Your Honor.
And Mr. Stroud obviously advised Mr. Turner and TNF that it was in their best interest to attach a mortgage to the Granger entities as opposed to Mayaca Farms. Is that true?
I'm not privy to exactly what was said, but certainly you are correct, Your Honor, that Mr. Stroud drafted the first version of his workout documents approximately 9 days prior to mediation.
So he drafted them on behalf of TNF, correct?
By April 13th of 2015, that was just prior to the mediation. At the mediation, the appellant was represented by Mr. Knowles. So I don't believe it's clear in the record, Your Honor, that as of April 13th, Mr. Stroud was acting on behalf of the appellant. But certainly at that point, he was acting as a 50% member of appellant, that being Utopia Fresh South, which was owned by Mr. Turner. But at the mediation, Mr. Granger was represented by Anthony Abate, and certainly Mr. Turner and his entities were represented by Mr. Stroud. And then Judge Sleet, you were correct when you referenced the April 30th, 2015 date where Mr. Stroud provides notice that he is representing the appellees. There is no question, as counsel raised, that Mr. Knowles did continue to represent the appellant post-mediation with regard to the Alistar refinance. That was agreed to by the parties. But again, the continued representation leading into the bankruptcy and post-bankruptcy was all specifically contemplated and consented to based upon paragraph 11 of the escrow agreement. If I may, Judge Sleet, I'd like to go back to the period of time that you referenced, the Christmas tree lot conversation. At that point, the money was gone. Mr. Turner asked Mr. Knowles to look into it. Mr. Knowles did. He specifically confronted Mr. Granger. Mr. Granger then said, I've talked to Turner. We're going to continue to talk, and it is what it is. Essentially, the money is gone. It wasn't until after Mr. Turner specifically asked appellant's CPA, the Shin firm, to prepare an audit that the parties knew that just under $3.1 million had been taken by Mr. Granger and or his entities.
Ms. Hines, and all this, analysis about what could have, should have, and ought to have been done. At the end of the day, wasn't the Mayaca property blanketed by the mortgage spreader agreement to MetLife? Was there really any equity there anyway?
Well, it's interesting, Your Honor, because there's no question that during the spring of 2015, everybody knows, and Mr. Knowles has specifically advised Mr. Stroud that Mr. Granger's properties are heavily encumbered. The existence of the MetLife loan, the breadth of that mortgage lien was well known. However, during the course of the bankruptcy proceeding, as various properties owned by the Granger entities were sold and approved by the bankruptcy court, that ultimately freed up Myakka Farm, that allowed Mr. Granger to provide a second mortgage lien to his own personal creditors in an amount of $3 million. Again, that points directly to that remedy not being pursued at all by appellant's counsel post-petition. And as I've indicated, that is one of the primary bases for the proximate cause of the appellant's loss. I wanted to address the covenant of good faith and fair dealing raised by appellant. That issue is not framed by the pleadings. It was raised at the hearing on the motion for summary judgment. However, as I indicated in the answer brief, where the application of that good faith covenant of fair dealing, where it contravenes the plain language of the express terms of an agreement, that covenant should not be invoked to override those terms. The language of the escrow agreement and the collateral assignment are clear on their face. They are unambiguous. There is no breach of contract. Additionally, the language of the escrow agreement, particularly paragraphs 4 and paragraph 11, demonstrate that the remaining counts in the first amended complaint were properly the subject of summary judgment. Just want to check my time.
Oh, you're in
Okay.
good shape. You got about 5 more minutes.
Okay, thank you, Your Honor. I, again, want to go back to Mr. Knowles's conduct leading up to the mediation. It's important to note in the record that as of March of 2015, Mr. Granger admitted that he had taken the money without authorization and that the debt was owed to the appellant and that his actions needed to be corrected. The record also indicates that Mr. Turner did not want to handle what he phrases as the fraudulent diversion of funds in an adversarial manner. So this case on appeal by appellants has asserted that Mr. Knowles should have done things immediately back in December of 2014 or January 2015, to take an adversarial position. But that is not what Mr. Turner wanted to do. It was very important to Mr. Turner that the operations of appellant be affected as little as possible by this dispute, because if it got out, the concern was that the dispute would affect the operations of the packing house. Appellants in their brief have bold highlighted, as if it was an incorrect statement by Mr. Knowles, that the sole source of repayment was the packing house and that any remedy needed to inure to appellant. That is a true statement. Mr. Knowles recognized that recoupment of money from Mr. Granger, if ever possible, should not be paid directly to Utopia Fresh South or to Mr. Turner. That money had to be repaid to the appellant because that is where the money was when it was taken by Mr. Granger. So the undisputed facts in this case and the conduct by Mr. Knowles, in our opinion, demonstrate that Mr. Knowles did not engage in any conduct that caused redressable harm to appellant. He took the action that he was asked to take in a non-adversarial manner. He suggested that pre-suit mediation, and he did not represent Mr. Granger or his entities at that mediation. I would ask this panel if it has any further questions of me at this time, and if not, I will conclude my presentation this morning.
Thank you very much.
Thank you.
Miss Anthony, you got 4 minutes.
Thank you. So I just wanted to follow up a little bit more on with respect to Judge Sleet's questions of whether or not Mr. Knowles had violated the escrow agreement or breached the escrow agreement. And I was focusing on the fact that although one document is titled escrow agreement, the collateral assignment of membership interest also provides for Mr. Knowles as an escrow agent. So there are two agreements and duties under each of the agreements. So that is what I was referring to when I was talking about he breached his duties as escrow when he did not turn over the membership interest in the 2 days. And then with respect to the recordation of the mortgages, which seems to be one of the primary focuses in the summary judgment order, it was of record that Mr. Knowles hadn't done anything to attempt to comply with his duties in the escrow agreement with respect to the recordation of the mortgage, which had to be recorded in 3 different counties. He testified that he did not even have envelopes prepared to FedEx those mortgages out or anything. I think that's an important issue to show that he was not intending to comply because he had been working with counsel for the Granger entities to get the bankruptcy filed on an expedited basis.
Yeah, but he testified that he was ready to walk across the street to the Manatee County Courthouse at any time. And quite frankly, it's drivable to these other counties. You could have driven them on the last day, and given the exigencies of things, it wouldn't have been unusual to have somebody hand deliver them. But I understand your point.
And then I believe that Ms. Himes' statement that Taylor and Fulton did not object to the retention of the Porges firm as special counsel is not accurate. I believe that we objected orally at the hearing to consider that application for retention of the Knowles firm based on their current representation of Taylor and Fulton. And over our objection, the court did approve the Knowles firm because it was supposed to be for special counsel, and special counsel is, it doesn't matter if you have other interests. If you're special counsel, you don't have to be totally disinterested as you would be if you were primary counsel for a debtor. And then Mr. Knowles was the one that advised Taylor and Fulton that the recordation of the mortgage at the time of the workout would not have been in Taylor and Fulton's best interest, because that would have triggered a default under the MetLife mortgage. So he was in fact still giving Taylor and Fulton advice. He testified that he was representing Taylor and Fulton at the mediation that resulted in the ultimate workout documents. Additionally, it seems to be a big argument that bankruptcy counsel didn't pursue this mortgage that at the time appeared to not have any value and preferred the member interest. The member interest had significant value at the time of the bankruptcy, and that was their focus, Taylor and Fulton's focus. But that does not mean that bankruptcy counsel and Taylor and Fulton could not have at any point in the bankruptcy case sought relief from the stay to go ahead and get that mortgage reformed, recorded, whatever they needed to do. But they
You're over your
didn't
time,
get
Miss
that
Anthony,
choice.
just so you know. So please wrap up.
Okay, Taylor and Fulton did not get that choice because counsel for the Granger entities, including Knowles, requested a release on behalf of Granger and its entities such that that mortgage was not able to be recorded.
Okay. Thank you both very much. This is definitely not a straightforward case, and your briefs and your arguments were very helpful to us. Okay, have a good day.
Thank you.
Thank you.
Thank you.